When I started this series, I sort of started it with a perspective of talking about what litigation lawyers such as myself do through the lens of my own experience and my own so called career. That's why, rather ironically, I went almost directly into document review, just sort of as I did in my career. One of the things we were told, I remember when we were being oriented at K. Scholler as first years, was before you get involved in a case, you're assigned to a case, you work with a partner, take a look at the file. Get the red belt out, take a look at the file, see what's going on, understand the case. I will tell you that by the time I left K. Scholler, which was not a lot more than a year after I started there, I didn't still know what a file was. I didn't know where you would find it or what you would find in it. I did two kinds of things. I did research and writing to answer legal questions to help senior and more experienced lawyers understand legal issues and how to deal with them in the cases that they had, and also writing briefs or part of briefs, which are arguments, papers written down with citations to legal authority that are submitted to judges. I'm not going to do to you what was done to me in my career. Instead of going to the next section, which is our discussion of other kinds of paper discovery that take place at the beginning of pre-trial disclosure, I want to talk to you about what's in the file. No, forget it. I don't know what I was thinking. I'm not doing this methodically, and I'm not doing it properly. I'm not doing it with the appropriate level of preparation. As good as I am off the cuff, there's no excuse to use video to speak off the cuff like this about something that actually requires a certain amount of preparation and planning. I'll say this. The most important thing you can do if you want to be a lawyer, and the most important thing you should look for if you want to choose a lawyer, is to prepare, or is to see that that person that you're choosing as a lawyer prepares well. It's good if you have charisma, charm, good sense of humor, verbal adeptness. As I do. But you don't accomplish anything, and I've never accomplished hardly anything, and nothing you could depend on without preparation. It's true in every endeavor that you do. If you have natural talent, if you have presence, you're good on your feet, you're good at speaking, and you're a litigator, you are asking for a lot of trouble if you don't also have the self-discipline to prepare. Because you're going to get away with a lot at a low level, but you'll never advance beyond the low level. If, on the other hand, you don't have those qualities, but you do know how to prepare, and you still want to be a lawyer of any kind, including a litigator, with preparation, chances are you can make it happen. I know some people who are really duds who could never dream of talking into a camera like this about anything. But because they prepare well, they're successful in the profession. I'm not so vain as to think that I can just keep sitting here in front of the camera and talking to you about what I do, as I might with a family member or a friend. That's fine if you're doing it in person, and there's a personal relationship there. And I do feel as if we all have a personal relationship. I really do. But if you're going to make a video, you owe it to your audience to prepare, and I'm not prepared. So I'm going to end this series right now. I've got a lot of other things going on, a lot of other interesting projects, many of which are going to be reflected in video. You should understand that I have 18 minutes of video talking about the basics of a complaint in a civil action. It's not very good. So, good night. That's going to be it for this series.